Mike Chiruka from the Law Offices of Mike Chiruka. This afternoon we're going to talk about some recent employment law updates that will affect many businesses, primarily small to mid-sized businesses that have general managers or managers in their structure. The President has recently announced, as many have anticipated, that rather than trying to work through the Congress, he's going to be using executive orders to enact many of the changes that he would like to see done in his last term. One of these executive orders is going to be with the Fair Labor Standards Act and overtime. If you have a business such as a fast food restaurant, convenience stores, possibly banks or other mortgage companies, the target is executives, particularly the general managers or store managers of many of these entities, who are often treated as executives and are exempt from the overtime laws. The President's order specifically targets this type of employee and is taking the position that they will not be exempt from the overtime rules going forward. So if you have individuals that are in these categories, you can look to be paying them overtime at least time and a half in excess of the regular work week. This again will be by executive order. They have not defined all of the job categories, but in particular in the initial drafts they have highlighted store managers, loan managers, and convenience stores in particular for the type of employee that they're targeting. That's an update on the federal side, what to look for. On the state side, this might actually be a break for small to mid-sized businesses. If you are hiring or offering employment and you find that you make an offer to a candidate and they either refuse that offer or they just don't get back to you to take the offer, you should take steps under the new regulations to notify the Department of Labor and Industry that the candidate either refused the job or refused to get back to you. If you make that contact or you notify the department within 7 days of the offer that was made and rejected, the department will render that individual ineligible for unemployment comp. So even if you have a candidate who comes in and they turn you down saying that they took another job, you may still want to file the notice with the Department of Labor and Industry just to make sure that they're not turning that job down and so that they continue to accept unemployment comp rather than take on the new employment. The department has been really active in this. They've put out notices to most employers, to most payroll services of the new rules, and they have in most cases sent you in a packet probably the new form that you can actually file with the department. If not, you can go to the Department of Labor and Industry's website, and that form is on the website, is available for you to fill it out and then file it with the department to put them on notice. So this is an attempt to clean up some of the unemployment comp rules, and it's also an attempt to make sure that people comply with the rules, that they are accepting suitable work if they have that opportunity. Again, hopefully it'll be a chance for the small to mid-sized businesses to clean up some of the unemployment comp that is out there and hopefully lower all of our rates if we go forward through the new year. If you have any questions on the new form or what your responsibilities are as an employer that's offering employment to take advantage of it, please feel free to give us a call, 717-232-4701, or alternatively go to our website at www.chirukalaw.com.